Good afternoon. Unfortunately, I'm going to begin my remarks today just as I did yesterday, offering my condolences to the families of the victims of yet another mass shooting in our country. All of us at the Justice Department, including the FBI and ATF, will continue to support the Half Moon Bay community in the difficult days ahead. And as I said yesterday, the Justice Department is committed to doing everything in our power to protect our communities from the gun violence that is leaving no community in this country untouched. Today, the Department of Justice, joined by 8 states, filed a civil antitrust lawsuit in the United States District Court for the Eastern District of Virginia against Google. We alleged that Google has used anti-competitive, exclusionary, and unlawful conduct to eliminate or severely diminish any threat to its dominance over digital advertising technologies. These technologies, which are known as ad tech, automate advertising sales by website publishers to online advertisers. When an internet user opens a web page that has ad space to sell, ad tech tools almost instantly match the website publisher with an advertiser looking to promote its products or services to the website's user. This product and process typically involves the use of an automated advertising exchange. This exchange runs a high-speed auction designed to identify the best match between a publisher selling internet ad space and advertisers looking to buy it. As alleged in our complaint, for 15 years, Google has pursued a course of anti-competitive conduct that has allowed it to halt the rise of rival technologies, manipulate auction mechanics to insulate itself from competition, and force advertisers and publishers to use its tools. In so doing, Google has engaged in exclusionary conduct to severely weaken, if not destroy, competition in the ad tech industry. As detailed in our complaint, we allege that Google's anti-competitive conduct extends to 3 significant elements of the digital ad buying process. First, Google controls the technology used by nearly every major website publisher to offer advertising space for sale. Second, Google controls the leading tool used by advertisers to buy that advertising space. And third, Google controls the largest ad exchange that matches publishers and advertisers together each time that ad space is sold. As a result of this scheme, website creators earn less and advertisers pay more. That means that fewer publishers are able to offer internet users content without subscriptions, paywalls, or other forms of monetization. Our complaint alleges that Google has violated Section 2 of the Sherman Antitrust Act by monopolizing the market for the technology used by publishers to offer ads on their websites, monopolizing or attempting to monopolize the ad exchange market, and monopolizing the market for the ad network technology that advertisers use to buy digital advertising space. Our complaint also alleges that Google has unlawfully tied its ad exchange and its publisher ad server in violations of Section 1 and 2 of the Sherman Act. And finally, we allege that the United States, as an advertiser, has incurred damages by reason of Google's violations of the antitrust laws. In addition to the declaratory relief, our complaint seeks damages and the divestiture of certain Google ad tech products. It also seeks an injunction preventing Google from continuing to engage in the anti-competitive practices described in the complaint and any other practices with the same purpose and effect as the challenged practices. I am grateful to Assistant Attorney General Jonathan Cantor, Principal Deputy Assistant Attorney General Doha Mekki, and the attorneys and staff at the Antitrust Division for their tireless work on this case. Monopolies threaten the free and fair markets upon which our economy is based. They stifle innovation, they hurt producers and workers, and they increase costs for consumers. Today's complaint is only the latest example of the department's work to challenge antitrust violations that undermine competition and harm the American people. No matter the industry and no matter the company, The Justice Department will vigorously enforce our antitrust laws. We will aggressively protect consumers, safeguard competition, and work to ensure economic fairness and opportunity for all. I will now turn the podium over to Associate Attorney General Vinita Gupta.
Thank you. I want to reiterate the Attorney General's thanks to the leadership and staff of the Antitrust Division for all their work to advance robust competition and to ensure that the American people have equal opportunity in the marketplace. I'd like to take a few moments to put this complaint into context. At its core, antitrust is about economic justice, and today's landmark action against Google underscores that it is a priority of this Justice Department to fight the abuse of market power. We know that free and fair competition is essential to economic freedom, and we know that anti-competitive conduct threatens innovation, weakens workers' rights, and stifles free expression. When any company, including a big technology company, violates the antitrust laws, our economy and our democracy suffer. Today's complaint is a perfect example of why competition matters. Americans rely on the internet for news and for community, and advertising revenue is essential for publishers to produce and share ideas and writings. But we allege that Google has captured that revenue for its own profits and punished publishers who sought out alternatives. Those actions have weakened the free and open internet and increased advertising costs for businesses and for the United States government, including for our military. Today's complaint is just one example of the department's broader efforts to root out anti-competitive behavior, regardless of how and where it may arise. Just a few months ago, the Antitrust Division scored a critical win for authors by blocking a merger of two major publishing houses, Penguin Random House and Simon & Schuster. The merger would have substantially lessened authors' compensation for their work and diminished opportunities for new authors to tell new stories. That merger was one of 5 that have been blocked or abandoned as a result of the division's recent work. Other abandoned mergers include 2 that would have strained the global supply chain by decreasing competition for shipping materials. And the Penguin Random House case is just one example of the department's efforts to protect workers. This past summer, we secured an $85 million payment from poultry companies to settle allegations that they fixed workers' wages and benefits. We've also reinvigorated criminal enforcement of the Sherman Act, including prosecutions for criminal wage fixing, labor market allocation, bid rigging, and procurement fraud. And we have acted to ensure that corporate directors do not sit on competing boards, reviving a vital and under-enforced rule of antitrust law. These efforts by the Antitrust Division are only a snapshot of the broader work happening across the department to advance economic justice, protect workers' rights, and ensure fair prices for products that we use and rely on, like health insurance, airline tickets, and food for our families. Today's suit against Google exemplifies that we will continue to marshal our resources across divisions to promote competition and protect American workers and consumers. I'll now turn it over to Assistant Attorney General Jonathan Kanter, who will speak more about the details of our complaint.
Good afternoon. Thank you, Attorney General Garland and Associate Attorney General Gupta. As alleged in our complaint, in late 2016, a Google digital advertising executive asked the following question in an internal email exchange. Quote, "Is there a deeper issue with us owning the platform, the exchange, and a huge network? The analogy would be if Goldman or Citibank owned the New York Stock Exchange." Unquote. The answer to Google's rhetorical question is yes. Indeed, there is a deeper issue, and that issue is the Sherman Antitrust Act. Google's alleged misconduct amounts to numerous violations of the United States antitrust laws, and that is precisely why we are here today. The lawsuit we have filed today seeks to hold Google to account for what we allege are its longstanding monopolies in digital advertising technologies that content creators use to sell ads and advertisers use to buy ads on the open internet. In the complaint, the department alleges that Google engaged in 15 years of sustained conduct that had and continues to have the effect of driving out rivals, diminishing competition, inflating advertising costs, reducing website publisher revenues, stymieing innovation, and flattening our public marketplace of ideas. The complaint filed today alleges that Google engaged in a pattern of acquisitions to obtain market dominance and, once it had obtained that dominance, a series of exclusionary acts to expand and to entrench its monopoly power. Here are just 5 examples. First, locking in content creators through tying arrangements. Second, manipulating auctions, including by giving itself a first look and then a last look advantage over competing ad exchanges. Third, blocking industry participants from using rivals' technology and punishing those that tried. Fourth, amassing and abusing troves of its rivals' bidding data. And fifth, depriving customers of choice by degrading the quality of Google's own products. Because Google dominates every part of the ad tech industry, it has the power to impose a surcharge on display advertising transactions, an industry where billions of dollars are transacted via instantaneous auctions each year in the US. Google's own documents estimate that it keeps on average at least 30 cents of each advertising dollar that flows through Google's ad tech tools. For some transactions and for certain customers, Google keeps significantly more. In addition to the harm that Google inflicts on content creators and online advertisers, the lawsuit alleges that Google's conduct has also harmed the United States government, including the US Army. Google's alleged anti-competitive conduct over the last 15 years is perhaps best explained through the words of Google's own employees and documents which are quoted extensively in the department's complaint. Here are just 5 examples. First, a Google employee characterized Google's ad exchange as, quote, an authoritarian intermediary. Second, a senior Google executive conceded that switching ad servers for publishers is, quote, a nightmare that, quote, takes an act of God. Third, a Google employee described the company's scheme to pay publishers $3 billion yearly by restricting access to Google Ads and, quote, overcharging advertisers. Fourth, a Google manager made it clear that, quote, our goal should be all or nothing. Use Google's ad exchange or don't get access to our advertiser demand. And fifth, a Google executive detailed the company's steps to, quote, dry out rivals. For more than 2 centuries, advertising in this country has funded newspapers and other avenues of free expression. Revenue from advertising has provided critical support for content creation, the sharing of information, the exchange of viewpoints, which promote a free and vibrant and healthy society. The Antitrust Division, and I'm so proud of this, has a storied history of safeguarding competition in offline media, from music to broadcasting to publishing. It is now just as important, if not more, to protect competition in the digital marketplace of ideas, where powerful network effects make monopoly power even more durable and harmful, and the abuses by companies with monopoly power like Google even more pernicious. In closing, I would like to thank the unbelievably hardworking, dedicated, talented, and extremely awesome staff of the Antitrust Division, whose tireless efforts to untangle the complex web of Google's alleged conduct resulted in today's filing. I am also deeply pleased to thank the Attorneys General of California, Colorado, Connecticut, New Jersey, New York, Rhode Island, Tennessee, and of course the Commonwealth of Virginia. And their extremely talented staffs. We've enjoyed an excellent and constructive working relationship with our partners at the state attorneys general. And I'd also like to thank the U.S. Attorney's Office of the Eastern District of Virginia, who will join us in filing this important and historic case. Thank you, and I look forward to answering your questions. Today is truly a historic moment.
All right. Stefania. Hi, Stefania from the Financial Times. I was wondering whether there, and forgive me if it's already in the complaint, but if there will be efforts to pursue specific individuals in relation to these violations beyond the corporate entity being Google itself. And aside from that, it was mentioned that this sort of alleged monopolistic control of the market was reached also via a series of previous acquisitions. And I was wondering if there will also be sort of an additional focus on trying perhaps to seek a form of sort of divestiture when it comes to those acquisitions, or if it's now sort of too long gone to try to pursue that.
Yeah, so the complaint only alleges a corporate entity as the defendant. Is that right? And with respect to the second question, the complaint does seek divestiture, part of the ad tech, at least part of the ad tech stack, the three parts that we've been talking about today.
Dave Michaels.
Dave Michaels from the Wall Street Journal. Could you address why Justice has filed this suit when there's a similar suit already out there filed by Texas and other states? And could you perhaps explain a little bit how the complaint might be different if it is from the Texas lawsuit?
Yeah, so on the first part, the Clayton Act, Section 4, permits the United States to file suit, particularly seek damages in a circumstance where it is itself an advertiser and has harm. So that's the explanation for that. It's our responsibility. I'd be happy to turn over to Jonathan to talk about the second question.
Sure. Thank you. First and foremost, we conducted our own investigation, and that investigation occurred over many years and involved investigation in meticulous detail by the Antitrust Division staff and the staff of attorneys general. That resulted in, I have it here today, a complaint that's nearly 150 pages. And in these 150 pages, we detail many facts, many episodes that individually and in the aggregate have maintained numerous monopolies. And so we think it's extremely important that we file this case on behalf of the American government, the American people, and we believe that this complaint has allegations that will support violations of the antitrust laws. And there is numerous detail. While there may be some similarities with other cases that are filed, we're focused on our case, the results of our investigation, and we believe it paints a compelling case.
So on the Google matter, Google points out, or their response to this appears to be that the department is trying to pick winners and losers. If you would mind responding to that and what they believe is perhaps a threat to innovation as a result of actions like this. And if I could follow up with you, Attorney General, since you're at the mic. The former Vice President Pence has turned over documents that were found at his home in Indiana to the FBI. There's now a review, we understand. I'm wondering whether you believe the Justice Department should approach these cases, which seems to be a widespread problem of handling of classified information, differently. When people come forward with these fines, should there be immediately a criminal investigation, or is there something else that should be done as a result of this, since this seems to be a lot of them?
So on the first question, we don't pick winners or losers. We pick those who violate the antitrust laws. Those are the people we sued. In this case, we sued Google because we believe it violated the antitrust laws. You won't be surprised with respect to the second question that I give the same answer I usually give, which is I'm unable to comment on your question.
Mr. Garland, I'll give you another opportunity not to comment on that question.
Thank you. I've been looking forward to it.
Our reporting on the recovery of the documents at Mr. Pence's residence seems to indicate that the Department of Justice was involved at the very start. Can you give us a sense as to whether or not this incident is being preliminarily investigated with an eye towards appointing a special counsel or assigning this to an existing special counsel? And as a follow-up question, just in the broader sense, you do weigh in on issues of policy. In the newspaper business, we say that 1 episode is a story, and 3 is a trend. Do you think there needs to be a policy change, either in a regulatory sphere or in a statutory sphere, to address what seems to be this difficulty of presidents and vice presidents retaining classified material?
Well, as you expect, I'm afraid my answer is going to have to be that I'm unable to comment on this.
Great, thank you all.